Attorney General Nessel. Earlier this week, your office dismissed charges against 7 individuals who were charged with illegal actions during the clearing out of the Michigan encampment at U of M. There's been a lot of misinformation about the case and the execution of search warrants and ongoing vandalism, and we would like to hear directly from you what happened.
Yeah, thanks for that totally unexpected question. And I want to say in advance that I cleared this with Noah, and I said, I know I'm going to get asked, but I want to be able to talk about this. I want to be able to give as much of the story as I possibly can about what happened with these cases, but I'm going to be like completely taking over your event and holding it hostage. But I think it's important that we talk about it because so much of everything that happened with this case involves anti-Semitism at levels and in areas formally, frankly, that I've not seen before, I've not experienced as an attorney, certainly not as Attorney General. First of all, I want to clarify how these cases came to my department because, you know, what was shocking to me were that stories were actually printed in places like The Guardian and then recirculated on places like Stateside, which I really respect Michigan Public Radio. So to hear these inaccurate stories about how these cases came to be reviewed by the Department of Attorney General, I heard it was from the Jewish regents that they forced me to take these cases. I heard it was from NOAA and also from the Jewish caucus because of the money I get from them. I heard it was from Jewish donors. You know how those cases came to my office? Debbie Dingle. Debbie Dingle, I don't know if you know this, not Jewish, but it had to be some sort of Jewish influence. Now, it's not unusual for a congressional representative to call up the Department of Attorney General and to call the Attorney General herself and say, I'm really worried about what I see to be criminal activity occurring, and either the local prosecutor is not doing anything about it or they're not well equipped to do anything about it, but I am scared about what I'm seeing and I think the AG's office has to take action. And that happens all the time. And we say, okay, we'll take a closer look at it. You know, we have jurisdiction statewide, so we can go any place in the state and do that. But when this was talked about, no one cared that it wasn't like the Jewish, you know, cabal that came and like swept these cases to the Department of Attorney General. It had to be because of the Jews. It was not, it was Debbie Dingle. And again, that's her doing her job, saying, will you please review these cases that seemingly no one else is reviewing. So I think that was something that I was not expecting to see in regard to these cases. We reviewed dozens and dozens and dozens of cases, things that had occurred at the honors convocation and at graduation and outside the art museum and many things. We only charged out of the dozens and dozens of individuals who were brought to our attention as potentially having engaged in illegal activity. We only ended up charging 11 of them. And none of these cases had been reviewed by the local prosecutors. Not as though someone else had looked at it and said, well, I'm denying charges, and then we said, oh, we're going to authorize. No one had looked at these cases at all. And I want to say this, and I want to make sure that people understand me when I say this. We don't charge people based on their beliefs. We don't charge people based on their cause. We charge people based on their actions, and that action has to be criminal in nature. And that is why we charged these 11 cases. Not all of them were directly related to a particular protest. Some of them were malicious destruction of property cases or ethnic intimidation, as it was then called, and people have pled guilty to those things. But most of the cases involved the encampment that was there for about 30 days. Last year, you'll remember. And when we talk about the encampment, I think it's important that people know and understand the facts because you're not going to hear them presented unless I talk about them right now. First of all, it's illegal to have an encampment. Nobody gets to do that, and no one had done that for 30 days in the history of the Diag of the University of Michigan. And I've been at many, 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 many protests during the course of my lifetime in the Diag, including when I went to the school back in the late 80s and early 90s and was engaged in many protests, but never anything involving an encampment. 11 times the fire marshal came to the encampment to say, this is unsafe. They had a generator in there, they had candles, they had wood pallets, they had chicken wire that surrounded the tents. They had no real easements or walkways. And the fire marshal, in his estimate, said that it would only take 4 seconds, once something caught a fire, 4 seconds for the entirety of that encampment to burn to the ground with everyone in it who would never be able to escape because of the chicken wire around it. So he said, this is so dangerous, it will kill everyone there, potentially, and in the surrounding areas, and if you know the area, and many of you do, that's where all the academic buildings are, that's where the libraries are. So 11 times the fire marshal tried to negotiate and get them to set up a new encampment that would be safer. And they said, we'll even permit one for you, because of course this was unpermitted. But no, they refused to leave. And at long last, finally, because of this significant safety hazard, the police came in with a lawful order to ensure that the encampment was dispersed and removed, and so that there would be a sense of safety there. And individuals were given multiple chances to leave. Anyone who did leave didn't get charged with anything, even if they had been there the entirety of those 30 days, got charged with nothing. It was literally just the people that stayed through tables and chairs at the police, banded together and pushed against the police physically to try to stop them from clearing the encampment. And those people were charged with fairly low-level offenses, probationable offenses, resisting and obstructing a police officer. But in my career, I've never seen anybody be able to treat a police officer that way while they were in the course of executing a legal order and not get charged with anything. They were simply being treated not differently than other people, but treated the exact same as anyone else who engaged in that kind of conduct as it relates to a police officer. So the cases were charged. We presented the evidence to the court in the Ann Arbor District Court, and that included several days of testimony from the fire marshal, from police officers, hours and hours of tape. Everything was captured on videotape. The judge's job at the district court level is really to do two things. One, you set a bond immediately, but number two, you make a decision as to whether or not there is probable cause to bind the case over to trial, to circuit court, to another court. The end. That's your job. But the judge said he would not make a ruling on the evidence of the case. And first he said that the cases had to be adjourned because 3 of those 9 people that were charged in that matter were undergraduates, and he wanted to allow them to graduate. I don't understand why just having the case bound over to trial, nobody was going to jail or prison, why you had to adjourn it several months, but fine, we did not object to that. But then the next thing that happened was a motion to disqualify me as the prosecutor of the case because I was too biased to pursue these cases anymore. The same claim, by the way, that had been made against me by Rashida Tlaib. She wouldn't say why I was biased. I was just biased. Now, let me make sure that people understand what this motion, like how damaging this motion is. In order to disqualify a prosecutor, normally there's got to be one of a couple things. Either you have a financial interest in the case, and I can assure you I did not, or there's a personal relationship, like you know those people, or your family knows those people, or they used to work for you, or something. I don't know these people at all who were charged. And we have never, in the history of the state, we've never seen a black prosecutor and had a motion to recuse that prosecutor saying that they couldn't be fair if there were any kind of allegations that potentially the defendants were racist. We've never seen a case where a female prosecutor was disqualified from a case saying that she couldn't be fair because there were allegations that the defendants might be sexist in nature. We've never seen a Christian A prosecutor sought to be removed from a case, saying that they couldn't be fair because there was something that the defendants had said or done that could be deemed to be anti-Christian. And yet the first Jewish Attorney General in the state of Michigan, the motion said, could not be fair to these defendants because they were pro-Palestinian activists. So we had lengthy arguments on this, followed by lengthy briefings on it, and then the judge said they were going to have evidentiary hearings in regard to this matter. Something that I've never seen in my almost 35 years that I have been either a prosecutor or a defense attorney in the state of Michigan. Never seen anything like this before. Then, in addition to that, the Jewish Federation of Greater Ann Arbor filed, sent an email, and they put out a public statement basically saying that they found that to be horrifying because it would be the first time that a prosecutor was ever removed from a case based on their faith or their gender or their race or any factor like that, and they objected to it. They sent it, unfortunately, to the court, which they should not have done. But that happens quite a bit, where you have an outside party who's not a lawyer send something to the court. Generally speaking, the court just says, I'm not going to read this email because I'm not allowed to see this because it might influence me. Or I'm not going to read this letter that was sent to me because I'm not allowed to read it. It might influence me. But instead, what the court said was that he was going to launch an investigation into the Jewish Federation of Greater Ann Arbor. A full-on investigation, something, again, I've never seen, 35 years. So now we're at a point, right, where the Jewish Attorney General is being investigated, the Jewish Federation is being investigated, everyone is on trial except for the defendants. I'm sorry, I know I'm going really long with this. I promise I'm going to wrap it up. And, you know, but this would have meant multiple more court appearances that my staff would have had to make every time they went in there, screamed and yelled at in a circus-like atmosphere and interfering with their ability to do other work. And no end in sight on this case because the judge seemingly was not going to rule on the actual evidence in the case. You might remember all the times you heard people saying, drop the charges, drop the charges. They didn't say, I want my day in court. They don't say, I want the judge or a jury to review the evidence. They just wanted the charges dropped because they didn't want anybody to see the evidence, nor did the judge intend to rule on the evidence. And so after reviewing the situation and understanding that all of these defendants would be receiving probation, these weren't murder cases, they weren't sexual assault cases, they weren't domestic terrorism cases, they were probationary cases. And the fact that it was significantly impacting the work of our office, significantly impacting my work. My staff had to start canceling events because every event I did, even job fairs at the law schools, were being interrupted and shut down by the protesters, that at long last, we simply had to make a decision as to what to do with those cases. And so we elected that rather than me being put on trial for being a Jewish prosecutor, and rather than having the Federation be put on trial for sending an email they should not have sent, but that get sent all the time, that we would dismiss the charges against those particular defendants. Now, hear me when I say this. There are other cases that have been brought up in the context of all of this that involve, I hate to use the word vandalism because it trivializes when you have F Israel spray painted on the Jewish Federation of Detroit, or you have elected officials where you have, phrases like, I hope you die, spray painted, or other, upside down triangles, which are generally a symbol of I'm going to attack or kill people who live at this house, that are spray painted on your car or on your home, windows broken into in your house, canisters of noxious fumes and chemicals thrown into your window in the middle of the night. Hear me when I say that I intend to vigorously pursue charges in those very serious cases. And if there is another attempt to remove me from the cases because a Jewish prosecutor can't possibly be fair in prosecuting criminal conduct, then I am willing to fight, and I will take it all the way to the Supreme Court if I have to. But I wanted everyone to understand the context in which these other cases were dismissed. It's not because I did not truly believe that these individuals were guilty of the crimes they were charged with. And by the way, that's not bias. I hope that every prosecutor who charges a case really thinks the people are guilty when they charge it. I'm not a judge. I'm not expected to be a neutral party. I'm an advocate on behalf of crime victims, on behalf of the people, on behalf of public safety. But that is what occurred in regard to those particular cases, but that is not a signal, nor should it be, that I don't intend to be a tenacious advocate on behalf of law and order, on behalf of justice, and on behalf of pursuing crimes that are committed against this community and all communities in the state for the rest of my time in office.